Well, thank you, Mr. Speaker, and I rise today to speak to Bill C-7, which proposes to remove safeguards contained in the existing criminal code provisions for medical assistance in dying, as well as to expand eligibility. This is a grave matter, one that should not be treated lightly. Its impacts will be significant, most especially for vulnerable Canadians. It is important that we get this right. Now, before I get into the substantive issues contained in this bill, I would like to add my voice to those who previously urged the Minister of Justice to appeal the Superior Quebec Court's ruling to the Supreme Court. 1 month after the Quebec Superior Court decision, 72 organizations who help Canadians with disabilities wrote to the Minister calling on him to appeal the decision. Less than a week later, 300 physicians signed a similar letter. Since then, many others have voiced their concerns as well. Mr. Speaker, referring to the Supreme Court would have been the more prudent course of action, as it would have provided Parliament with a framework within which it could legislate. Alas, those many voices, as well as those of my Conservative colleagues in the House, went unheeded. Further, Mr. Speaker, when Parliament passed Bill C-14 in 2016, the legislation required a parliamentary review of its provisions to commence at the start of the 5th year following royal assent. That review, which was to also include a study of the state of palliative care in Canada, could have taken place this past summer, but instead, this government opted to shut down Parliament. That, Mr. Speaker, was time squandered. There was much wisdom in including a mandatory review when Bill C-14 was adopted. Now, instead of giving this matter the thorough attention benefiting its gravity, parliamentarians are being asked to rush legislation through to meet the judicial deadline of December 18th, unless, of course, a third extension is sought and granted. We call that putting the cart before the horse. It is therefore vital, in the short time that we have to review these changes to the made clauses in the Criminal Code, that we hear from as many Canadians as possible, from all walks of life, and especially those likely to be most impacted by any expansion of the current laws. The two most troubling changes to the existing law are the repeal of the provision that requires a person's natural death be reasonably foreseeable. It is to be replaced with the term grievous and irremediable. The other is the elimination of the clause requiring a 10-day waiting period between when MAID is requested and when it can be administered. These changes need careful study. What will the unintended consequences be? Moving forward, the priority of the Conservative Party is ensuring this type of legislation includes safeguards for the most vulnerable in our society, as well as the conscious rights of physicians and all other healthcare professionals. One concern in that regard is ensuring adequate safeguards to protect those who may not have the ability to consent. Many of those involved in the care and advocacy for citizens with disability are sounding the alarm. We would be well advised to heed them. I would like to quote from the letter from the 72 advocacy groups written to the Minister of Justice just last fall. They were among those who urged the minister to appeal the Quebec Superior Court's decision in Trunch and Gladue. In their words, when the original medical assistance in dying legislation was debated in Parliament, there was a clear understanding that MAID must have limits, that individual rights must be balanced with protections not only for the most vulnerable citizens, but for society as well. One of the most important foundations of our Canadian identity is that we are a caring, compassionate country. We place a high premium on being inclusive and tolerant while working hard toward the accommodation and integration of minority members of our communities. And yet, if the Quebec decision is allowed to stand, or as it stands now codified into law, we will be in serious danger of losing this fundamental element of our Canadian identity. Our neighbours and our loved ones living with disabilities already continually experience the devaluation of their lives. They are frequently told, often bluntly, that they would be better off dead. The letter goes on to make the point that the unintended consequences will be to, quote, erode provincial health responsibilities for expert clinical care and social support of citizens who are fragile. Mr. Speaker, it is crucial that adequate safeguards are included in Bill C7, and that will be one of my highest priorities. Another concern worth heeding is the removal of the end-of-life criterion. As the Council of Canadians with Disabilities stated in their October 2000 letter to the Minister of Justice, and I quote, without the equalizing effect of the end-of-life criterion, which guarantees that the common thread between all persons who access an assisted death in Canada is that they are all dying. With the proposed changes, persons with disabilities will be able to gain access ultimately because they are disabled. A worse stereotype couldn't be institutionalized in law. That disability-related suffering, largely caused by lack of support and inequality, justifies the termination of a person's life. Mr. Speaker, I now want to take some time to address the need for palliative care in Canada and the importance of such end-of-life care. As mentioned previously, a study of palliative care was to be included in the mandated parliamentary review. This should have happened before Parliament took action to expand the current criminal code provisions. Again, I would like to turn to the experts on this, the doctors and other healthcare professionals who provide end-of-life care and face these life and death decisions each and every day. The Canadian Society of Palliative Care Physicians strongly advocates for the prioritization of adequate investment in and enhancement of palliative care services. Without access to high-quality palliative care, some patients who are suffering may feel that MAID is their only option because their suffering has been inadequately addressed, or they perceive that their families or social supports must carry an excessive burden. Data regarding availability, access, quality, and types of palliative care, for example, special palliative care, are essential not only for those requesting or receiving MAID, but in general, in order to better inform areas for improvement. Palliative care should remain distinct from MAID to ensure clarity and to avoid risk of confusion and the potential for people to refuse palliative care services because they may confuse it with MAID. During my own consult on BSIL C7, the doctors I have spoken to have stressed that palliative care is more than providing access to morphine, and the public need to be educated on that. As well, concern was expressed that elder abuse and financial motives, such as inheritance, are contributing to an abuse of MAID. Another concern is the temptation to save health care dollars with MAID. It is easy to conclude that MAID is more cost-effective than continuing care. This raises ethical questions about its potential overuse, particularly as the previous safeguards are being lifted. These are all serious concerns. I look forward to hearing what these doctors and health professionals on the front lines recommend as we move forward. Mr. Speaker, I would also like to make a brief comment about the need for the conscious protection for physicians. Doctors are concerned that they will be forced to administer MAID. I have been advised that the Ontario College of Physicians has created a policy that doctors have to arrange a referral. Some doctors have confided in me that they are considering leaving their professions over this. Suffice to say that physicians should have their freedom of conscience protected, and that fundamental freedom needs to be codified in law as has been done in Australia. In closing, I urge this House to take our responsibility to review this legislation seriously and to do as thorough a job as possible, keeping utmost in mind those most affected by the decisions that we make. As those 300 physicians said in their letter to the Minister of Justice, for all patients who seek an assisted death, we must first ask if they have access to adequate and funded social and living supports, as well as exemplary health care and symptom management, in order to assure that they are not seeking an assisted death. Mr. Speaker, I think we can and must do better. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And in good part, I disagree with the member's assessment, Mr. Speaker, with respect to that where we need to appeal it to the Supreme Court of Canada, or somehow a lot of the discussion around the bill hasn't occurred. We have been discussing this virtually since the 2015 federal election, and it has had all sorts of committees, direct and indirect input. In fact, even this year, over 300,000 people participated through providing input. There's been an enormous amount of consultation, and a lot of that consultation never ended after we first passed the legislation. And I think that what we see before us is some changes that were learned from, whether it's a court order or it's just from what Canadians have been saying for the last while now. And does the member not agree that it's time, at the very least, to allow it to go to committee, where we could get that further additional feedback on some of the specifics that have been raised here in second reading?
The honourable member for Essex.
Well, thank you, Mr. Speaker, and through you to the honourable member, and thank you very much for the question. I guess I'd say two things. The first thing I would say is, if the government didn't prorogue Parliament, we'd have had a whole summer to have more of these discussions. The second thing I would say is, much more discussion needs to happen, and I'll tell you exactly why, Mr. Speaker. On just this past Friday, I spoke to two doctors via Zoom, and they're the ones that told me specifically 4 points. Number one, they're considering leaving the profession. We cannot afford to lose any more physicians. They were taught to save lives, not to take them away. What a powerful statement. They told me that 800 physicians have signed a new letter denouncing them from being forced to refer a patient to another doctor to get made, and more would sign that letter, but they're afraid that the hospitals will literally blackball them, and they are in fear of losing hospital privileges. Much more discussion, Mr. Speaker, has to happen over this, and it definitely will be going to committee. I look forward to it. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. L'honorable député.
The honourable member for Matisse-Matane-Matapédia. Thank you, Mr. Speaker. I thank my colleague for the speech. He spoke about December 18th, the deadline, and the fear that we're going too fast. On the contrary, I think the government has asked for enough extensions to the courts. Does he not agree with me that a reasonable, predictable death is too restrictive, and that we have to stop setting aside the dignity of young people and those who are so ill? It has to be sent to committee and passed in order to respond to the Quebec Superior Court judgment.
Well, thank you, Mr. Speaker, and through you to my honourable member, thank you very much for the question. Yes, as I just mentioned earlier, definitely more discussion needs to happen at committee, no doubt. But, Mr. Speaker, you know, I'll continue to go back to our parents and our doctors and our clergy. More discussion has to happen around that as well, because I'm really concerned about the victimizing of them. For them to not be able to speak their conscience, to be forced to not discuss life and death I find it to be a real issue. Mr. Speaker, as I mentioned before, the doctors don't lie. The doctors told me Friday the shortcomings in this bill, and that's why I'm looking forward to get C7 to committee and fix it and amend it as required. Thank you, Mr. Speaker.
We have time for about a 25-second question or a 25-second answer. Questions and comments? The honourable member for, must be late in the day in Kelowna Lake Country.
Thank you, Mr. Speaker, and I'd like to thank my colleague from Essex. You had mentioned palliative care, and I wanted to ask you, especially at a time right now where families are separated, due to COVID-19, and people are feeling isolated. We see palliative care as an important part of the healthcare service, and it's not readily available to everyone. So I'm wondering if you can maybe just expand on that.
The honourable member for Essex in 25 seconds or less, and I just want to remind the honourable members, even though we are close and it's very intimate, but please place your questions through the chair. Thank you. The honourable member for Essex.
Thank you, Mr. Speaker, and through you to my honourable member, thank you for the question. I guess because I've only got 25 seconds, I will say this. Palliative care is very near and dear to my heart. They did a wonderful job when my meme had brain cancer and kept her incredibly comfortable. But I will tell you that the discussion within our family wasn't about how to end her life. It was how to make it more comfortable and last a little bit longer. So by all means, the palliative care is vital. Thank you. Thank you, Mr. Speaker.
Order à l'ordre, conformément à la
It is my duty pursuant to